approach to licensing. I also commended the government for the fact that there's that 30% ownership provision in there in relation to investment in the marijuana medical industry in Barbados. The point I then made is that though that is a good thing, because of the costs associated with these things, local capital, because of a narrow pool, will find it very challenging to access that level of ownership. That is all. I supported the position of the report and the bill on these matters. He needs to listen.
I remember Mr. Joseph.
He needs to listen.
Mr. Speaker.
But they don't listen to their own, so I don't expect them to listen to me.
Mr. Speaker, I listened, but I'm very happy, sir. I'm very happy that the leader of the opposition has found so many occasions in the course of one debate to say that he liked what the Barbados Left Party is doing. This is remarkable, and I hope to see this happening on many, many future occasions. My takeaway, sir, from what the member said was that he was critical. That's my takeaway. And I believe that it might be the takeaway of other people. And therefore, in the event that other people took that view, it is still important for me to say, sir, that the same position was taken in relation to light and power by the cabinet that he then supported, and he had no difficulty with it then. Plain and simple, sir. So we have provided then that all Barbadians can get involved. Now the hue and cry, popularly known as the human cry, that has been made about regulations, sir, it's crocodile tears. Really they are. Really they are, sir. You know, the course of legislation acknowledges that regulations are what are called subsidiary legislation. They are subsidiary to the main statute. Now, I want to assure this chamber that the regulations, Mr. Speaker, are being worked on by a combination of the team from the Ministry of Agriculture, the Ministry of Health, and the Attorney General's office. They're being worked on, sir. But there's a logic behind it. You see, you can't draft regulations unless you know what it is being subsidiary to. Simple point, might have misled the opposition. Okay, but Mr. Speaker, we've gone to select committee. We always knew we were going to select committee, but I'm glad he joined us. Glad he joined us. So at the end of the process of crafting a bill, we can now get into the minutiae of preparing the regulations. Now, Mr. Speaker, I don't know what my learned friend is particularly nervous about. But let me just say a few things. Marijuana, cannabis, whatever you call it, is the subject of a piece of legislation in Barbados, which is called, sir, the Drug Abuse Prevention and
Cap
Control.
131, I remember.
Yes,
Cap 131.
Now, bottom line is, sir, that act makes the possession of marijuana illegal. That act, sir, is based on the Single Drug Convention of the early 1960s. It was called the Single Convention on Narcotic Drugs of 1961, sir. The important thing to note about this particular convention is, I believe it is, I will tell you the precise article, but that convention says that marijuana or cannabis is unlawful except for medicinal and scientific purposes. That article, sir, is article, I just want to cite the specific article, but take my word for it, sir. I'm having a little trouble finding it now. I'll ask the leader of business to find it. It's on the line. So here's our challenge, sir. Here's our challenge. We have to establish an industry that caters to the two exceptions to the treaty so that we can have a scientific purpose and a medicinal purpose. So in other words, sir, we have to carve out scientific and medical. But carving them out, sir, requires that they don't mix. So in the functioning of this arrangement, we have to make sure that there are no opportunities for medicinal and scientific cannabis to somehow find its way into, I suppose you could call it recreational use, which is the one that would not be permitted under the Act or under the treaty. Now, sir, in relation to that, we've therefore provided, well, we haven't completed regulations yet. We've provided, sir, in the Act that the regulations will deal with such things as regulating, restricting, and prohibiting premises, vehicles, or equipment used or intended to be used in connection with the supply of medicinal cannabis. Because by international standards, sir, you cannot go and throw 300 pounds of medicinal cannabis in the back of a station wagon. That is not sound practice. The vehicles are specially devised, they have cameras in them, they have GPS devices to show exactly what route they're taking. If they deviate, it has to be recorded, and all those kinds of things. It also prescribes the category of persons who can apply for each license. It regulates or prohibits the transport of medicinal cannabis, including in relation to specific areas of Barbados. It also deals with standards and requirements, or it will deal with standards and requirements as to the security of access to premises. So there's a whole raft of regulatory arrangements, sir, that are being put in place so as to carve out and put up a big wall between medical and scientific cannabis and other use of cannabis. And I think, sir, that allows me to segue to something that was mentioned by the leader of the opposite, by the Prime Minister. And after that, I will shut up. Mr. Speaker, on page 10 of our manifesto, the Barbados Labour Party says, and I will quote it for you, Barbados Labour Party says that we will hold a referendum on the decriminalization of recreational marijuana. Not we may hold, not we want to hold, we will hold a referendum on the decriminalization of recreational marijuana. The referendum will be held after a period of public debate. On page 25, sir, under the rubric medical marijuana, we say significant strides have been made in the use of marijuana in pain management and for the treatment of a range of medical complaints. The BLP will not deny Barbadians access to modern treatment modalities. Now, sir, interesting thing. We've gone from medicinal marijuana, medicinal cannabis, on one end of the spectrum, and recreational cannabis is on the other end of the spectrum. So, for medicinal cannabis, we said we will legalize it, so that's what we're doing. For recreational cannabis, we're going to hold a referendum, so that will come. But, sir, if there's one thing about government, I repeat it, you cannot run from the people you serve, and you must always be open to listen. Mr. Speaker, as part of the consultative process, I was challenged by one of the groups that met with me as Attorney General. And the essence of that challenge was, essentially, well, sir, AG, where do you put sacramental use? Where in your spectrum do you put sacramental use? You have medicinal cannabis on one hand, and when, in the words of the individuals, when I am having my devotions and enjoying my religious experience and relating to my God, that's not medicinal. It may be therapeutic, but it's not medicinal the way you're describing it. And heaven forbid that you could contend that it is recreational. After all, when an Anglican goes to church on Sunday and sings their hymns and their masses, you don't say that they're engaged in an act of recreation. So you can't put my faith in that category, plain and simple. And it was a challenge, I believe, that was thrown out to me, sir. And I had to begin by recognizing that sacramental use fell neither into the category of medicinal cannabis or into the category of recreational cannabis. One is too restrictive, and the other one could arguably be downright insulting. After all, you're reducing my faith now to something that you do on Kadooment Day for feta or something like that, which is clearly not it. So the question then that I had to answer is, what do you do with sacramental use? Now, sir, I only have one profession. I take my profession seriously. And as a lawyer, sir, I did a fair amount of research. There was a case decided earlier this year called Maccabees versus the Attorney General of St. Christopher and Nevis, sir. And in Maccabees, Mr. Justice Eddie Ventors, Professor Eddie Ventors, in a well-reasoned argument, found, sir, that in those circumstances, and perhaps I should tell you the facts, a Rastafarian in St. Kitts was arrested under the equivalent of their Drug Prevention and Control Act. And he argued successfully that I am using this for the purpose of my faith. So you are preventing me from being able to present myself to God in the way that my faith requires. And that is unconstitutional. And that argument was supported by Professor Ventors in his decision. And Professor Ventors in his decision referred to a number of cases from way across the ocean in South Africa, commonly called as Prince 1 and 2. And in Prince 1 and 2, a similar issue was canvassed. And in South Africa, their highest court of appeal found that in those circumstances as well, for the country's laws to hold that a person a Rastafarian who was using cannabis for the purposes of his sacrament to be guilty of committing a criminal offense, that too infringed on his constitutional rights. Now, Mr. Speaker, I have taken to Cabinet, and I have got Cabinet's approval for the preparation of a bill to bring to this chamber, which will facilitate the use by members of the Rastafarian faith of cannabis for the purpose of their religion. Mr. Speaker, for us to continue to prohibit that would be to continue to breach their fundamental constitutional rights, sir. And not just rights guaranteed by the Barbados Constitution, but rights guaranteed by the International Convention on Civil. We signed another convention, sir, in 1972. I'll give you the exact name because I don't want there to be any doubt, sir. Yes, sir, it's the International Covenant on Civil and Political Rights. And that covenant says, sir, in Article 18.1, everyone shall have the right to freedom of thought, conscience, and religion. This right shall include freedom to have or to adopt a religion or belief of his choice, and freedom either individually or in community with others, and in public or private to manifest his religion or belief or worship, observance, practice, and teaching. The Barbados Constitution, sir, which came after the treaty was in place, but before we signed on to it, is expressed in similar words, and I don't think I need to repeat it, but the language is almost identical. Sir, in the same way that we go where the science takes us, we have to go where the law requires. Now, the details, we've begun some consultations with that faith. And yes, sir, we understand that there will be some people who will try to find a way of using that system. But you know, sir, that is no excuse for denying a person his fundamental human rights, sir. We've come to this chamber to amend the Offense Against the Person Act so as to prohibit the mandatory imposition of a death penalty. Why? Not because there are people on the side of the Barbados Day Party who don't support hanging. Not because there's an overwhelming number of Barbadians who say get rid of hanging. We came to this chamber and we made all of the consequential amendments, sir, because the law, as espoused by the CCJ, found that the continued imposition of a death penalty as a mandatory result of a guilty conviction was an infringement of his constitutional right. And yes, that was a case that was a Barbadian appeal and it bound us. We complied and we changed our law to accommodate this thinking, sir. Now, as AG, do I tell my cabinet colleagues, well, let me wait until somebody sue the government before we choose to do what is right? For me, sir, I suppose I'm a Christian just like you. I grew up in the Church of God. Sir, there have been times in the history, sir, of religious faiths when there was so much religious intolerance that if you were Protestant, you were hunted down and killed. We only recently has the Irish, the war in Ireland between, I think, the Catholics and the Protestants been quelled. Because this whole idea of religious intolerance and standing in judgment over who is right and who is wrong, sir, has prevailed across the modern world for 1 day, 1 year, 1 decade, 100 years, too many. Now, I have no doubt that there are people who will probably, I don't know, call down hellfire and damnation on this particular position. But I believe, sir, that it is solid in terms of constitutional theory. It is the right position in terms of constitutional rights. And, sir, at the end of it all, it is the right and decent thing to do. I am not a Rastafarian, but I'm not a Muslim either. I'm not a Hindu. I'm not a Buddhist. But yet still I acknowledge, sir, that those individuals have the inalienable human right guaranteed by our Constitution and guaranteed by all of the human rights treaties that we've entered into to not only practice their faith, but to have a manifestation of their faith, sir, in the way that suits them and their God. Now, Cabinet has very kindly agreed that I can pursue that legislation, and I hope to be able to have a draft available within the next few weeks. And I know, sir, that I can hear it now. So this was just a way to bring you closer to recreational use. That's what they said about medicinal cannabis, sir. But I'm not going to veer away from doing the right thing because there's a perception that it brings me closer to X, Y, or Z. Every time you sell a knife at a hardware store, you bring somebody closer to harming somebody else. But knives, sir, are still selling. Now, Mr. Speaker, I said that I would speak about that and I will shut up. I believe that this debate has been enlightening, and there are some things about it that some Barbadians will find awkward, some things about it that they will find even inconsistent with their own belief systems. But, sir, fundamental is the right of a human being to access medical treatment that caters to his needs. And equally fundamental, sir, is the right of a human being to manifest his religion. And those, sir, are the principles by which we stand. My final word is to the Leader of the Opposition, sir. You can change your policy many, many, many times, but your principles remain steadfast. I'm obliged to you. Mr. Speaker, having concluded debate on this resolution, I beg to move that this resolution do now pass and that the report be adopted.
Questions that the resolution do not pass and the report adopted. All those honourable members in favour, please say aye. Those against, please say no. We think the ayes have it. This resolution is now passed and the report adopted.
You going to chairman of committees?
Third reading.
You going to chairman of
Yeah.
Good job.
Order number
3.
4.
Which way against training? Third reading? Third reading. Okay, right there.
Order number 4, sir. In the name of the Honourable Attorney General, to move the third reading of the Medicinal Cannabis Industry Bill 2019.
Mr. Speaker, I beg to move that this bill be read a third time.
Second, please.
The question is that the aforementioned bill be ready a third time. All those honourable members in favour, please say aye. Those against, please say no. We think the ayes have it.
Passing and citing.
I beg to move, sir, that this bill do now pass and be cited as
Medicinal Cannabis Industry Act 2019.
the Medicinal Cannabis Industry Act
2019.
of
2019.
2019, sir.
Second, please.
The question is that this bill be now passed and so cited. All those honourable members in favour, please say aye. Those against, please say no. We think the ayes have it. This bill is passed and so cited.
Motion.
Mr. Speaker, I beg to move that the Honourable Member for St. Michael West Central do now sit as Chairman of Committees.
Question is that the honourable for St. Michael West Central be appointed as Chairman of Committee. All those honourable members in favour, please say aye. Those against, please say no. We think the ayes have it.
You have it? No. No. Wait. Order number 14, sir. In the name of the Honourable Leader of the House, to move that the House resolve itself into Standing Finance Committee to consider the grant of sums of money for the service of this island. Thank you. Have to move that in.
I beg to move, sir, that the Speaker do not leave the chair and the House resolve itself into Standing Finance Committee.
The question is that the Speaker do now leave the chair and the House resolve itself into Standing Finance Committee. All those honourable members in favour, please say aye. Those against, please say no. We think the ayes have it.
This House is in committee.
Standing Finance Committee.
Standing Finance Committee.
Yes, Mr. Acting Chairman, in the name of the Honourable Attorney General, to move the passing of a resolution to grant the sum of $481,855 from the Consolidated Fund and to place it at the disposal of the government to supplement the estimates to 2019 to 2020 as shown in the supplementary estimates number 4, 2019 to 2020, which form the schedule to the resolution. Head 30, Office of the Attorney General, in the amount of $481,855.
Mr. Chairman, I will try very hard not to keep the chamber too long on this matter. This supplementary, sir, seeks provision for the amount of $481,855 under the subprogram of the Registration Department, and is intended, sir, for the purpose of constructing 3 judges' chambers in the White Park Road Supreme Court complex. Mr. Speaker, what has given rise to this is a very simple matter. As members of the chamber would know, we took a decision to increase the number of High Court judges from 8 to 13. Now, we've not changed the number of Court of Appeal judges, so we still have 5 Court of Appeal judges, and those judges are adequately provided for. But by increasing the number of judges, we've had to make provision for judges' chambers. Now, perhaps we didn't use the fancy term, and we should just say judge's office. But a judge will spend a lot of time when he's not on the bench in his chambers, researching, writing, and so on. And you simply can't get along without it. Sometimes judges will even have hearings in their chambers, especially matters of injunctions and so on. Now, sir, we're trying to better utilize the space in the White Park Road complex. Members would recollect that earlier this year, in April to be precise, we moved from our temporary accommodation in Warrens back down to White Park Road. When we moved to Warrens, we took the opportunity on that occasion to do some work that was within our budget at the time, and that work was to deal with building additional courtrooms and things of that sort. But the strictures of birth, sir, we were operating under a very tight financial schedule. Other arrangements, therefore, for the new judges it was necessary to defer those financial arrangements until we actually had the commitment for the judges and to actually have the judges in place. So it really was just about managing our cash flow. Those judges have been appointed, sir, and we are managing for the moment because 3 of the appointed judges have not yet taken office. Those judges, sir, would be 2 Justices of Appeal, Mr. Justice of Appeal Designate Bell, Mr. Justice of Appeal Designate Cumberbatch, and one of the High Court judges, High Court Justice Designate Shona Griffith. Those 3 judges will not take office until January. So in the meantime, we are using the accommodation that's there to facilitate all the judges. So as it is, all of the judges have chambers, but 3 of them are in temporary accommodation. Accommodation that will have to be vacated when the substantive holders of the office come back. So this is just to accommodate, this is the works which will allow for the construction of those 3 chambers. Now, sir, we are repurposing space. We are taking, in one instance, space that was used by support staff. We're making an adjustment in that area so as to accommodate one of the judges' chambers, and that support staff will be adequately accommodated elsewhere on that floor. And the other area will be, it's currently a void, so two chambers will go there. So judges' chambers, 3, and then there's some other work that is being done for that purpose. Now, sir, just to give colleagues a brief update on where we are. In relation to the appointment of the judges, I think, sir, that the stakeholders have responded positively. I think that Barbados recognizes that the appointment of additional judges is a clear demonstration that we are serious about fighting crime. I should also remind the chamber that there are 2 additional temporary criminal court judges. So they're also in the chamber mix. The criminal court, sir, is currently staffed by 3 full-time judges, one of whom is Mr. Justice Graves, who, as you know, has come back in from Bermuda. The 2 new appointees, one permanent, one temporary, are not yet sitting in full criminal trials because there's a period of training that has to take place. Sir, all new judges, in the case where you're already a judge, fine, you've gone through all that training, but in some instances we've appointed individuals who have not had significant judicial experience before, and they also have to be trained. And sir, in relation to the criminal bench, in years past we used to send our judges down to Trinidad to sit in criminal courts with their criminal judges. But we decided to be practical. On this occasion, we have experienced criminal judges who are as capable of giving our new criminal judges the instruction and so on as if they went to Trinidad. And therefore, those 2 new criminal court judges, I suppose I could respectfully call them novices to the High Court. So those individuals are receiving a period of tutelage or even pupillage at the feet of, not literally, but at the feet of 2 of our more seasoned judges. And that experiment, sir, is working well. In relation to the establishment of the full-time commercial court, the registry has prepared a compilation of all of the matters that would fall within the category of commercial litigation, so that those new judges will have a corpus of work that they're going to be getting through. But even with them, they're also going to receive judicial training. And in fact, I think they were engaged, I recollect they were engaged in some significant training last week. I believe, sir, that come January, we will have the full complement of judicial officers fully engaged, and we will then begin to see them systematically eroding the backlog that exists. The backlog, sir, that we have, especially in our criminal jurisdiction, is outrageous, and I say it is a source of embarrassment that it has been allowed to get to that. We've had to make arrangements for the appointment of additional prosecutors, additional court marshals, additional legal assistants, but in every case, sir, we've gone to those individuals first, as first protocol, who had been retrenched during BERT, so that the instances where individuals who would have served in those capacities but were retrenched, who still have years ahead of them to serve, we've brought them back as our first pick to try to fill those positions. What I expect to happen to roll out within the next, there are some challenges along the way, sir, but I expect to be able to roll out very shortly the e-filing, and that e-filing will take a lot of pressure off of the system. We recently passed an amendment to the Evidence Act and to the Interpretation Act so that attorneys at law can take affidavits. That has already begun to have some impact, sir, on the number of people who have to walk across the court to stand up in front of a legal assistant to sign documents. That is now, for the most part, a thing of the past, so that lawyers can take affidavits and so on. Some of our changes don't need to be huge changes, sir. Some of our changes can be small, but in those instances, they are certain to be able to reduce the workload on the admin staff at the registry, reduce the cost of the service providers, the lawyers, reduce the inconvenience to the litigants, and produce an overall benefit and improvement to the system. In terms of our estimates for the year, sir, we are not moving to the stage yet where every judge will have a judicial assistant. We will continue the system of judges sharing judicial assistants until such time as we have more money available. It would certainly be more efficient for a judge to have his own judicial assistant, but we're just not at that place now. So we are engaging three additional judicial assistants to be able to serve the new judges in the High Court who are coming on. Sir, with those words, I ask that the Chamber support this particular resolution. I beg to move that head 30 stand part.
The question is that head 13 stand part. All honourable members in favour, please say aye. Aye. Those against, please say no. Think the ayes have it.
Beg to move, sir, that you do now report to His Honour the Speaker the passing of one bill in Standing Finance Committee. One resolution in Standing Finance Committee.
The question is that I now report to His Honour the Speaker the passing of one resolution in Standing Finance Committee.
Beg to move that you read it first, then second.
Those in favour, please say aye. Aye. Those against, please say no. I think the ayes have it.
George?
The chairman of committees is reporting the passing of one resolution in committee.
Mr. Speaker, I beg to move that this resolution be read a first time.
The question is that this resolution be read a first time. All those honourable members in favour, please say aye.
Aye.
Those against, please say no. Me think the ayes have it.
Mr. Speaker, I beg to move that this resolution be read a second time.
The question is that this resolution be read a second time. All those honourable members in favour, please say aye. Those against, please say no. Me think the ayes have it.
Mr. Speaker, I beg to move that this resolution be now agreed to.
Beg to second that.
The question is that this resolution be now agreed to. All those honourable members in favour, please say aye.
Aye.
Those against, please say no. Me think the ayes have it. This resolution now stands passed.
Mr. Speaker, with that, we've come to the end of today's sitting. I beg to move the adjournment of the sitting until the 12th of November, 10 a.m. Tuesday the 12th, 10 a.m.
The question is that this honourable chamber be adjourned until Tuesday, the 12th day of October 2019 at 10 a.m. in the forenoon. All those honourable members in favour, please say aye.
12th day of November.
The 12th day of November 2019. All those honourable members in favour, please say aye. Those against, please say no. And we think the ayes have it. This honourable chamber stands adjourned until Tuesday, the 12th day of November 2019 at 10 a.m. in the forenoon.